Okay, so today we'll be talking about working holiday visas. And working holiday visas are becoming quite an important source of employees for Australian businesses. So today we'll talk about, with more of a focus for employers, what working holiday visas can do for you and risks you can see from having working holiday visas on staff. We'll first of all have a look at some recent changes to the working holiday program. Then we'll just cover a bit of context. We'll look at how to apply for an initial working holiday visa. That's not something most employers would look at normally, but it does give you a bit more context about what types of people you'll see and what they needed to show to get their visas in the first place. Next, we'll talk about work rights on working holiday visas, and this will really be the bulk of our presentation today. And these are the issues that most employers see from day to day. Next, we'll talk about extending working holiday visas, and this is something that employers often get involved in. And this is where employees work in a regional business for, say, 3 months and then can extend their visa. So we'll have a look at some of the requirements there and what sort of documentation needs to be provided when that extension is being applied for. And then we'll look at some tips for employers as well at the very end. So this chart here just goes through which are the main and most important source countries for working holiday makers. And I think the thing to notice from this is that the classic British and Irish backpacker, where they're making up the bulk of working holiday makers, is no longer the case. What we're seeing now is we're seeing a lot more diversity in the program. And the reason for that is that there are a lot more countries that are now eligible for working holiday and work and holiday visas. We'll see them in a minute. What you see in this chart is both the first visa and the second visas. And what you'll see here is that the second visa holders, the ones that have done the 3 months in regional areas, are now making up quite a significant proportion of the total. So there's about 32,000 of them in Australia versus 113,000 first visa holders. And you'll see for some nationalities, there are almost as many second visa holders as first visa holders. So if you look at Taiwan, for instance, there's 9,000 first visa holders and 7,000 second visa holders. So you see that a lot of people are seeing this not as a 1-year visa, but as a 2-year visa. And that is an opportunity for regional employers for sure. So there were some changes introduced in November 2018, and let's just go through these just so that you have a feel for those. So the first one we have here is that where somebody is working in animal and plant cultivation, the normal rule that they can only work for 6 months for a particular employer doesn't apply. They can work for up to 12 months. And this is a really interesting change because there's been no change to policy and there's been no change to the legislation. The only information we can get on this is from the announcement and from the web pages on the department's website. Basically what it says is that in this circumstance, you don't need to apply for permission to work beyond the 6 months. And that's really interesting. When you look at the page which talks about the process for getting permission to work beyond 6 months, it actually says, please don't apply for permission to work beyond the 6 months if you're in one of these circumstances, which includes the animal and plant cultivation. So quite an interesting change. Second one is expanded eligibility for second work and holiday visa. We'll talk about that in a minute. Next one's really interesting is we talked about the fact that you can have a first or a second working holiday making visa. They're also talking about a third working holiday visa if you then work for another 3 months. It's another potential opportunity for regional employers, but that doesn't come into effect straight away. They also increased the age limit for the initial working holiday visa for Canadians and Irish up to 35 maximum age. And they increased the application caps for work and holiday for 6-2 applicants from certain countries. We'll go through those in more detail. And what you'll see in a lot of these slides is I've actually put the source of the information, where this information came from. And I think with working holiday makers, it can be quite complicated. You do see a lot of information that does contradict each other. And so going back to the source is often a really good idea. So I've given the links to the information where I've got it from on these pages here. So let's talk about the initial working holiday visas. And the reason I wanted to talk about this is that whilst employers don't get involved at this stage, it is important for you to understand how these people have ended up in Australia. And there's actually two different pathways. The first one we have is the traditional working holiday visa, which is a 417. And really, this is the streamlined approach. It's an online application. It's relatively light touch in terms of documents. And most of the people you'll see in Australia will hold the 417, the working holiday visa. But it's not the end of the story. There's also another visa subclass called the 462, and that's called the work and holiday visa. So slightly different name. And in general, what you have for these is that there are quotas that apply for each country. They need to establish they have functional English. Often they'll need to hold post-secondary qualifications or be working towards them. They often need a letter of support from their home country, and that can be either easy or difficult to get. And generally, it's a paper application with a certain amount of documentation to support the application as well. So it's a lot more cumbersome to apply for than the 417, but in most cases, it gives them the same work rights whilst they're in Australia, but with some subtle differences in some cases. So with the working holiday and work and holiday visa, the first thing we need to look at is the fact that the person holds an eligible passport. So I've just listed here the eligible passports for the 417, which is the streamlined application. And you'll see here that most of the countries are from Western Europe, and we also have a few exceptions like Hong Kong and Taiwan and Korea, Japan. So East Asia and Western Europe, they're the main countries that we see. These are the list of countries for the 462 work and holiday visa countries. And you see that they're quite different. Generally, it's more the Eastern European countries. We also have quite a few Asian countries there. We also have Peru there, a couple of South American countries. And probably the biggest one there in terms of numbers is the USA. We don't have a working holiday arrangement with the USA, but we have a work and holiday arrangement with the USA. And what that means in practice is that the USA is quite a streamlined application process. It is an online process for work and holiday, so it works very similarly to the 417. All other countries, it is a bit more cumbersome. They do need to apply using a paper application and a lot of evidence. In terms of the first working holiday visa, there's some common criteria there. The person needs to be between 18 and under 31 when they apply, except if they're from Ireland or Canada, they can be up to 35, but must be under 36. Need to hold a passport from the approved country. They're the countries we just went through. They need to be outside Australia when they lodge and when the visa is granted. You need to have not previously entered Australia on a working holiday visa. And this is the general rule in that you can generally only hold one working holiday visa in your lifetime, unless you do the regional work, in which case you can get a second working holiday visa. And we'll talk about that more in a minute. I mentioned before that they increased the quotas for some of the countries for the 462 work and holiday visa. Here's the countries they changed. So you can see quite a big increase for Spain, a really big increase for Israel, and quite a significant increase there for Peru as well. So they've obviously had a good experience with people coming from those countries and decided to increase the numbers for them. In terms of the common criteria, you have to also be a genuine visitor in that your primary purpose is to come here for a holiday rather than to work. And I have seen a few situations where, and I really hope people are not into this side of things, where people are being secured for work by offering a visa, a working holiday visa offshore, and they come here primarily to work. You need to be aware that if somebody offers you a scheme like that, then you need to be aware that possibly that person is not a genuine visitor and would fall foul of this particular rule. So I would not recommend that sort of program if you're looking at it. You need to have sufficient funds. Generally, that's about $5,000 plus a return airfare, and that would cover the first 3 months of stay. You need to have reasonable employment prospects and not be accompanied by any dependent children. In terms of the visa duration, if you're outside Australia, you need to make your first entry within 12 months and you get 12 months stay once you arrive in the country. So you think about an older person who might be 30 when they apply for the working holiday visa. If they turn 31 during processing, that's fine. They need to be under 31 when they lodge, but they can certainly be over 31 when they enter Australia. So what happens is when the visa is granted, they then get a 12-month window to enter. And so long as they enter during that 12-month period, they get 12 months stay from when they enter Australia for the first time. So this type of visa is a little bit complicated. It's different to a 457, which has a definite start and finish date. It is dependent on the first entry date, and that's dependent on the grant date as well. For second working holiday and work and holiday applicants, if they hold a working holiday visa when they apply and they're inside Australia, then they get 24 months from the date of first entry. If they're overseas when they apply, so they've had their working holiday visa, they've finished that and gone back home, then they'll get 12 months from the date of grant, similar to that above case where the applicant's outside Australia get 12 months from the date of first entry. The next item I'll cover is the work limitation. Now, the work limitation is probably the most important one for employers, I would say. Working holiday and work and holiday visas, they have a visa condition that says that they can only, a holder can only work for a maximum of 6 months for each employer. And that applies per visa. And this can be quite a complicated scenario, but just imagine somebody has had a working holiday visa and they've applied for an extension and their working holiday visa expires. What will happen generally then is that they go onto a bridging visa. And that's a good thing because on that bridging visa, it's a new visa and they get another 6 months. So the 6 months may be up for the main visa, but once that main visa expires and the bridging visa comes into effect, they potentially get another 6 months. And then when the extension is granted, that's another new visa. And so that means they get another 6 months on that visa. So they could potentially work for the same employer for quite a long time. 6 months on the first visa, up to 6 months on the bridging visa. Hopefully it's not going to take that long, but it can. And then up to 6 months on the second working holiday visa. In terms of labour hire, if you're using a labour hire company to source your staff, it's the end user that counts. That's the rule. So basically, if there's a labour hire company and they place the working holiday maker with you, then they get 6 months with you. And then they can be placed with a different employer, but with the same labour hire company. But because the end user has changed, they can get another 6 months with the same labour hire company, but with a different end user, if that makes sense. Training with the employer does count as employment, and the rule does not apply for foreign businesses operating in Australia. So if you happen to be a foreign business, you don't have this 6 months work limitation at all. In terms of self-employment, this is a complicated one when people are working on ABN. But technically speaking, in most cases, if someone is genuinely self-employed, then they will be able to continue working for more than 6 months in their own business. But that gets complicated when they only have a limited number of people they are contracting for. So if they have a single end user that they're providing services for, they're treated effectively as if they're an employee. So trading under an ABN is not a way around the 6 month limitation. If it's really the same position and they don't work for a number of different end users, then they're counted as an employee and that 6 month rule would apply. In the case of paid or unpaid leave, that counts towards the 6 months, but otherwise breaks of employment don't count. So if somebody wants to leave and travel around Australia in the middle of their employment with you, the most favourable way to treat that is if they're on their employment has ceased and you rehire them when they come back. If you count it as paid or unpaid leave, then that period of time will count towards the 6 months. And another important thing to note is that the limitation applies whether they're working part-time or full-time with you. There's no pro rata rule when it comes to this work limitation. If they're working 20 hours a week and they work for a week, that counts as a week towards the 6 months work limitation. If you do need somebody to continue working after that 6 months comes up and they're not in a position to get another visa, such as a bridging visa or a second working holiday visa, you can apply for that in certain circumstances. So the process is that you need to apply on the form 1445. And they recommend doing that at least 2 weeks before the end of the 6 months. They don't leave it to the very end. And there are specific circumstances which are set out in policy as being acceptable reasons for extending that 6 months. So the first one we have here is the situation where you have an au pair. So where the children are under 12 and the person who's working as an au pair, then they can get an extension. If it's a highly skilled project that's unexpectedly over time, for a very short amount of time, say days or weeks, you can potentially get a 6 month extension. If there's a pending decision, I just had a connection issue with the Zoom meeting. I should be back and audible now. Can everybody just send me a quick note if they're having a problem with the audio? Great. Okay, I'm sorry about that. So I might just start this slide again and go through the work beyond 6 months. I think the issue started in slides, so I'll just cover this topic again. Sorry if you've had enough of this already, but I'll just go through this for people that want to look at the 6 months. It's actually quite an important thing for employers. So if you do want somebody to continue working for more than the 6 months that they have with you, you can apply for permission to work beyond the 6 months. And the process is that you use the form 1445 and don't leave it to the last minute. Apply for that permission to work about 2 weeks from the end of the 6 month period with you. First situation, I don't imagine it applies to many of you, is if the person is working as an au pair with children under 12 years old. In that case, they can get permission to work beyond 12 months, the 6 months. Next one that might apply is for highly skilled projects. So if a working holiday maker is working on a project that's really important and there's been an unexpected delay to the end of that project, then that's another basis for applying for permission to work. Another one that does come up quite often is where you've applied to sponsor somebody or they've applied for a partner visa. So how this might work is that they've worked with you on a working holiday visa for, say, 4 or 5 months, and you've decided this person is somebody that you do want to retain, and you apply for the temporary skill shortage visa, the 482, to sponsor them to stay in Australia. Technically what would happen is if their working holiday visa still continues, they would not be able to continue working for you beyond the 6 months. But you can apply for permission to work beyond the 6 months in that circumstance on the basis of having that TSS visa application in the system and being processed. They also do mention another circumstance where somebody is waiting on a partner visa, and this can take a long time at the moment. It can be easily 12 months, 24 months to get a partner visa, and that is another basis for applying for permission to work. Where somebody is waiting out a period of time due to a workers' compensation payment, that's another situation that's covered. Cleanup or rebuilding work after a major disaster. So if you've had a major disaster in your area, this can be something to look at. Or work at a workplace affected by a major disaster. Say, due to heavy flooding, you haven't been able to harvest at the normal time, but you do need to still do that after the disaster has ceased. And I've given you the link here to the permission to work longer than 6 months on the Department of Immigration website. Makes for really interesting reading, and particularly around that issue of, do you need to apply for permission to work? The next screen here is about situations where permission is not required to work beyond the 6 months. And this is quite interesting reading on the Department of Immigration website. It does lay out certain circumstances which do not require permission beyond the 6 months. And the two main areas that are covered are the Northern Australia exception. And this is for Northern Territory and Queensland and Western Australia above the Tropic of Capricorn, if you're working in the following industries. So that's agriculture, forestry and fishing, construction, mining, aged and disability care, tourism and hospitality. These are all possible areas where you don't need to apply for permission. And we'll see in a minute that specific activities are covered by those. And if you are in those industries, you may well find that if the business is located in one of those areas, you don't need permission beyond the 6 months. They also mention plant and animal cultivation anywhere in regional Australia. And that's another really nice exception that's been brought in recently in the November changes. Okay, let's talk about the second working holiday visa. Again, this is something that the employer often gets involved in. If you're operating in a regional area, what happens is that if the person works in specific industries, in specific activities for 3 months in regional Australia, then they can potentially apply for a second working holiday visa. So the basic rules are you can either be in Australia or overseas when you apply. You need to have worked in an approved location. It needs to be 3 months of work whilst holding a working holiday visa, full-time equivalent basis with appropriate remuneration. I've done this chart because it gets really complicated when you're looking at this extension as to what activities are covered by which visa in which areas. So I've tried to summarise these here. So if you're looking at a 417 working holiday extension, which is the streamlined visa, that hasn't changed for some time. So the position needs to be in a regional part of Australia, and I'll give you the postcodes in a minute. And it needs to be in the following industries: plant and animal cultivation, fishing and pearling, tree farming and felling, mining or construction. So that's a working holiday extension, the 417. 462, which as I said, is a slightly different type of visa. It's called a work and holiday visa. In this case, the areas and activities are a little bit different. So it's important to know who has a 462 and who has a 417 because it may be different for them. First of all, plant and animal cultivation in regional area, that's also acceptable. But things like pearling and fishing and tree farming and felling are only possible if the business operates in Northern Australia, which is Northern Territory and north of the Tropic of Capricorn for Queensland and Western Australia. They also have an exception for Northern Australia for the tourism and hospitality industry. That's specifically mentioned there. And I've also included the work beyond 6 months rule here as well, because it's also sort of similar but a little bit different. So I've actually included the areas there just for reference, and this may be something you find useful when you're talking to your 417 and 462 holders, just in terms of what's going to be possible for them. And I mentioned before I'd give you the postcodes for the regional Australia, and that's relevant when you're looking at the working holiday extension, but also in some cases for the work beyond 6 months. So the ACT is not considered regional. New South Wales, excluding Sydney, Newcastle, Wollongong is regional. Norfolk Island, the entire island is included. Northern Territory, a whole territory. Queensland, excluding Brisbane and Gold Coast. Victoria, excluding Melbourne. Western Australia, excluding Perth. Whole of South Australia and whole of Tasmania are considered regional. So when you're looking at these extensions, it's important to understand what the 3 months work rule is. So basically for the 3 months work, it needs to be about 88 days, including weekends or rest days, 7 or 8 days, 7 to 8 hours per day in general, but really depends on the usual shift length for the employer. So the policy in this area talks about situations where people are doing shift work. If it's normal for somebody to be working, say, 5 days on, 2 days off, that's great. That's a normal working week for most of us. But other situations can come up as well. So if somebody's working 10 days on and 10 days off, that can in certain circumstances be considered normal for an industry and therefore considered to be full-time work. You may well find that the hours that people are working in that sort of shift are a lot longer, for instance. So that makes sense. So it really depends on your industry and what's normal for your industry. You can count more than one employer, so they don't have to do all of the work with you. Paid sick days, leave or public holidays count, but unpaid days due to severe weather don't count. So the next thing we talk about are the types of work. Needs to be in the specified industry that we talked about before and in one of the specialisations listed. Has to be the person's primary role. Generally, support services are not accepted. So they have to be really doing the activities most of the time to be counted for the second working holiday visa. The kinds of evidence they look at, there's a form 1263 or 1464 that you fill in as evidence of the employment. They'll need some pay slips, an employment contract. They'll want to see that the pay level they're getting paid is the normal remuneration, and that the person has really been receiving that salary and everything is declared through the ATO. A really interesting announcement that came through in November is the third working holiday visa. So at the moment, you can get the first one, no problems. Second one with 3 months of regional work. Now there may well be a third working holiday visa. So the third visa will be available if the person has done an additional 6 months of regional work. Not entirely sure what that means, whether it's 3 plus 3, 3 on the second and 3 on the first and 3 on the second, or whether it's 6 months of additional in the second working holiday visa. Not sure yet. Not coming in till the 1st of July 2019, so that's later on this year. I'm not sure whether the work can have occurred before the 1st of July 2019, so still waiting on all of those details. But potentially for regional employers, I mean, this could be a really good option. You can see from the numbers we looked at in terms of people in Australia, certain nationalities are really using the second working holiday visa. So expect the same nationalities to be quite interested in the third one as well. So these charts here just go through the different industry sectors and what's possible for each one. I'm not going to spend a lot of time on these, but I think they're good references if you're in the particular industry. And these top areas tell you what's possible in terms of the second working holiday visa and the work beyond the 6 months. So these are quite useful charts just for people that want a bit more information. So we've got the fishing and pearling, the mining, construction, tourism and hospitality, which is all about Northern Australia, age and disability care, which is all about Northern Australia as well. Okay, so with the working holiday visas, they can be a little bit complicated for employers to keep on top of. And I think the main things with these are keeping on top of the 6-month work limitation, depending on your industry, keeping on top of expiry dates, because by definition, the visa is a maximum of 12 months. Often they apply for another visa to extend their stay. So you may get bridging visas involved there, which are also difficult to track. And often with working holiday makers, they do change status. So knowing if they change status is very important. And the classic example of this is where somebody's on a working holiday visa, they can work full time. But if they change onto a student visa, often they can only work 40 hours a fortnight, so part-time, around 20 hours a week. So unless you're keeping on top of changes to visa status, you won't know that. And so you may have somebody working in breach of their visa conditions without you even knowing it. So the whole idea with vSure is that it just makes everything easy for businesses to keep on top of the visa compliance side of things. Easy to get people onto the system. We have a wizard now where you can actually put everybody on the system very quickly and easily just by sending emails to anybody that you're onboarding. And if they're an Australian citizen, they put in a copy of their passport or their citizenship certificate or the birth certificate. And if they're not a citizen, they put in their passport. And what will happen is that the system will OCR it. So grab all the information off the passport without any data entry from your side, and that allows you to straight away do visa checks on that person. Once they're in the system, really easy to do visa checks. You can literally press one button and it'll check everybody on staff. Give you a report that says who's got a problem and who's okay. Much easier to understand work rights and visa types. The information that comes back from Vivo can be a bit brief. So we just try to expand on that and give you a bit more information about what it means to you as a business. In terms of visa expiries, we'll make it really easy to keep on top of that. You can get a calendar reminder, SMS reminder, or email reminders that will tell you when people are expiring. And that's pretty important for working holiday visas because they're only valid for 6 months. We go through and check everybody's visa status once a month, once a quarter, once every 2 weeks, depends on your risk appetite. And that will give you a report about who's changed status, who now has an issue, or who is still fine. And that'll give you a heads up about any issues with your staff. It's also multi-user, so if you have a lot of different user locations, that's very important. You can make sure that you're on top of it for each department or location. And that makes it really easy to centralize everything, to just see what's going on in each of your branches. Multi-user, so you can set up as many user accounts as you like to keep on top of visa compliance. Okay, so if anybody wants more information, Matt's the best person to talk to. He's our client relations officer. So matt@vshore.com.au if you want some information on getting a demo. And if people have questions, I'm happy to take a few now. So send them through the chat window and I'll do my best to go through and take them. Anywhere in Australia for animal cultivation. Yeah, okay. Let me double check that. So, let me just see. So that's this slide here. So the 6-month work limitation. So let's double check it. This page here is a really good page on the Department of Immigration website. I would definitely recommend you print it out and go through it in detail. Yep, plant and animal cultivation anywhere in Australia. So you don't have to ask our permission to work with the same employer for up to 12 months if you work in plant and animal cultivation anywhere in Australia. So note, this is to do, it gets really confusing with the work limitation versus the visa extension, because the work limitation works very differently to the visa extension in some cases. So if you're getting confused between different pages, it gets a bit hard. So yeah, certainly anywhere in Australia, if you're working in plant and animal cultivation, you don't need to ask for permission to work beyond the 6 months. I just wanted to show you one other thing, which is how to apply for permission. And that's this page here, applying for permission to work longer than 6 months with one employer. So it goes through all this stuff. Goes through the certain situations where you do need to ask for permission to work, and the situations where you do not need to ask our permission to work longer than 6 months, see here, and they actually ask you to not do that if you don't need to ask for permission to work. So yeah, it can get confusing, but these 2 pages are probably the best ones to look at. The 6-month work limitation and the permission to work longer than 6 months. They make things a fair bit clearer when you're looking at these conditions. Okay, any other questions about the visa conditions or the permission to work or the extension? Okay, well, in that case, we might wrap up the presentation then. If anybody's got any questions, feel free to email me or Matt. So my email address is mark@vshore.com.au. If you've got any questions about how these visa requirements work, I've been in this for quite a long time now. I looked at the other day, and my first registration as a migration agent was back in 1999. So literally doing this for 20 years now. So it came as a surprise to me. It's gone very quickly. One thing about VShore I should explain is we don't actually do visa consulting. Whilst I'm a migration agent, we don't help with visa applications. But when it comes to visa conditions and such things, we really focus on that with VShore. So if you do have any questions about that, we're always happy to hear from people and always happy to help out where we can. Okay, thanks everyone, and feel free to drop me an email if you need more information. Thank you. Bye-bye.